Good evening. The City Planning Department, operating under the supervision of the city manager, has permitted the creation of an urban blight in the midst of Malibu, the likes of which has never been seen before. In so doing, the city manager and city staff have disregarded and violated procedural and substantive environmental laws, have demonstrated indefensible fiscal irresponsibility, have confirmed that they are tone deaf to community concerns, and have thumbed their noses to this city council and its commissioners, who are the gatekeepers of public policy, and also to the residents of Malibu, to whom all members of city government, elected or employed, are ultimately responsible. Now, I understand that I have a long list of procedural, substantive, legal issues that were violated, in my view, by this destruction of the field outside. There also are other policy issues as well as fiscal issues, but I don't have anywhere near enough time to discuss them. Now, I know you all have the right to ask questions during this meeting, and I would be happy, after I sit down, to come back and answer as many questions for as long as you'd like about each and every one of the procedural and substantive snafus that went on here. It is my understanding that the city manager and perhaps some staff are going to offer an explanation later. Conveniently, the public will not have an opportunity to respond to that after it occurs because it's not occurring before the public comment. It would be great if the public, after such an explanation is made, would have an opportunity to comment and explain why, if they don't agree with the explanation is wrong. I will say that it's my understanding that the city's main defense to its callous disregard of procedural and substantive law that governs this matter has been to assert that the destroyed field was used as a farm, was regularly plowed, tilled, or disked, and may even have had greenhouses or other buildings on it at some time in the past. This glib assertion is a non sequitur, which is not even relevant, much less dispositive of anything, does not excuse compliance with the legal requirements for specific assessments, studies, and findings, and would never be accepted by the planning department as an answer by a resident who wanted to tear up a field the size of the property in question without jumping through the necessary legal hoops, which might not be capable of being jumped through once a proper assessment, testing, and findings were put to the test. The legal protections for ESHA wetlands and land adjacent to ESHA and wetlands simply are not satisfied by the whim of city employees using what they believe to be their common sense. Moreover, for every person in Malibu who might believe that the destroyed field did not contain ESHA or wetlands, there's another person in Malibu who has witnessed evidence to the contrary, even within the past few years. That's why expert analysis, testing, and findings are required before a project of this magnitude and destructive potential is permitted to proceed. As I said, there's many other problems with this. I did send a long letter to City Council, and I think the public deserves to have a discussion of every single one of the legal infirmities that occurred here, but I also understand that my time is up. Thank you.
Thank you, Bruce.